Sudah. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. First of all, I would like to introduce myself. My name is Belinda, and I will be hosting the seminar today. On behalf of the organizers, I would like to extend my warm welcome to the Dean of the Faculty of Law, Brawijaya University, Dr. Ali Safaat, and the distinguished speakers, Professor Anselmo Reyes, Dr. Eliezer Sanchez Lazabalet, Dr. Sulaiman Dorloh, and Dr. Reka Dewantara. I also welcome all participants who attend this international seminar, Private International Law in Asia Pacific, which is organized by the Faculty of Law, Brawijaya University. Ladies and gentlemen, on this occasion, I would like to inform you the agenda of the event. First, the opening ceremony by Dr. Ali Safaat, the Dean of the Faculty of Law, Brawijaya University, followed by the presentation that will be delivered by the four speakers. After that, we will open a question and answer session, which will be led by the moderator, Dr. Afifah Kusumadara. Finally, we will have a photo session before the closing of the seminar. Ladies and gentlemen, to begin with, I would like to invite Dr. Ali Safaat, the Dean of the Faculty of Law, Brawijaya University, to deliver his opening remark. Please welcome.
Okay, thank you. Dear distinguished speakers, Professor Anselmo Reyes, International Judge, Singapore International Commercial Court, Dr. Eliezer Sanchez Lazabalet from Newcastle Law School, Australia, Dr. Sulaiman Dorloh from Sultan Idris Education University, Malaysia, and Dr. Reka Dewantara from Universitas Brawijaya, and all participants of this international seminar. Assalamualaikum warahmatullahi wabarakatuh. Good morning. May peace be upon all of us. Alhamdulillah, thanks to Allah, the Almighty God, in the midst of the COVID-19 pandemic, we can hold these productive academic activities as part of continuous education. This pandemic has indeed had a huge impact in all parts of the world. However, it has also encouraged the use of information technology to facilitate many international activities, meetings, and cooperations, especially in the field of education, which is implemented virtually. This pandemic has certainly affected the intensity of international relation and transaction. However, relation and transaction will not stop completely. Adjustment and the use of information technology instruments are needed to facilitate international contract and transaction. This will certainly enhance the development of international private law, not only during the pandemic, but post-pandemic, where I think the traffic of people, goods, and capital will inevitably increase both in the form of investment and trade. In this context, an understanding of national law, which has an international dimension in each country, is very important. We hope that this international seminar will enrich our horizon and support international cooperation in the Faculty of Law, Universitas Brawijaya. We express our gratitude to all speakers, Professor Anselmo Reyes, Dr. Eliezer Sanchez Lazabalet, Dr. Sulaiman Dorloh, and Dr. Reka Dewantara. And thank you to all participants who have attended virtually to take part in this international seminar. Last but not least, thank you to the committee, especially Ms. Afifah, Ibu Afifah, and the team who have initiated and organized this activity. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Dr. Ali Safaat. Now, it is time for the seminar presentation that will be delivered by our distinguished speakers. This presentation session will be chaired by Dr. Afifa Kusumadara. And without further ado, please welcome Dr. Afifa Kusumadara.
Good morning. Good morning, all invited speakers, Professor Reyes, Dr. Sanchez Lazabalet, Dr. Dorlo, and Dr. Dewantara. Also, good morning and salam to all participants. Welcome to this seminar. My name is Afifa, and I will chair this session. Let me explain briefly the order of this session. First, all speakers will deliver their presentation. Each of them will give presentation for 20 minutes. For 20 minutes. After that, I will open the question and answer session. The first speaker is Professor Anselmo Reyes. Let me present his short bio quickly. Just a moment. Professor Anselmo Reyes at the moment is, hold on, just a moment, is a judge in the International Commercial Court in Singapore. And then he is an expert in the private international law. And he already produced a lot of publication. And he also at the moment is teaching in the several Japan universities. So now let us listen to Professor Reyes' presentation. And before that, I would like to remind you, all participants, to please mute your microphone. So Professor Reyes, so now time is yours. Thank you. Could you please activate your mute, Professor Reyes? Activate your mute.
Thank you very much. We had a little problem with the muting because the host was kept me on mute at the moment. I apologize for that. I propose to divide my talk into 4 parts. My talk is on how the Hague Conventions on legal cooperation can help attract foreign direct investment to ASEAN countries in the COVID-19 era. In the first part, I propose to say something about ASEAN countries and their relationship with the Hague Conference and Hague Conventions. In the second part, I propose to say a few words about 4 Hague Conventions, 4 Hague Conventions dealing with legal cooperation. I propose to describe them very briefly and then to say something about how they might be adapted to deal with the COVID-19 era. In the third part, I will say something about how ASEAN countries can adopt the Hague Conventions on legal cooperation. And finally, in the fourth part, I will say something about how this would be of assistance to ASEAN countries in attracting FDI. Could I say beforehand that much of what I say has been inspired by the work of our moderator, Dr. Kusumadara, and her team of lecturers and scholars at Brawijaya University. They have been working on a book on Indonesian private international law, focusing, among other topics, on the relationship between the Hague Conventions and Indonesia and how Indonesia could benefit from adopting a Hague Convention. So I've been very much inspired by that work, which will be forthcoming, and it is hoped that that work will be published in English next year. Let me now say something about ASEAN countries and the Hague Conference and the Hague Convention. First, the Hague Conference. The Hague Conference was established in 1893, so it's nearly 130 years old. Its goal is the gradual harmonization of private international law across borders. So the law relating to cross-border relationships between countries, trying to harmonize that gradually so that in due course, all countries, both common law and civil law, will have a similar system of laws governing cross-border relationships, especially in matters of civil commercial matters, in matters relating to the well-being of the child, in matters relating to legal cooperation and cross-border civil procedure. Currently, the Hague Conference, which is based in The Hague in the Netherlands, has 85 members, 84 states, and one regional economic integration organization, REIO, that is the European Union. Now let's look at the relationship of the Hague Conference and the Hague Conventions with ASEAN countries. There are 10 ASEAN countries, and let me go through them very, very quickly. Brunei is not a member of the Hague Conference, but it is party to 2 Hague Conventions, one of which, the 1961 Hague Apostille Convention, I will deal with today. Cambodia is not a member of the Hague Conference. It is a party to 1 convention, the 1993 Hague Intercountry Adoption Convention. That is a convention dealing with the well-being of the child. Indonesia is unfortunately not a member of the Hague Conference, and unfortunately at the moment is not a contracting state to any Hague Convention. Laos is in a similar position to Indonesia. It is not a party to any Hague Convention, and it is not a member of the Hague Conference. Malaysia has been a member of the Hague Conference since the 2nd of October 2002, but Malaysia is not party to any Hague Convention. Myanmar is not a member of the Hague Conference and is not party to any Hague Convention. The Philippines has been a member of the Hague Conference since the 14th of July 2010. It is a party to 4 Hague Conventions, 2 of which I will talk about today, the 1961 Apostille Convention and the 1965 Hague Service Abroad Convention. Singapore has been a member since 9th of April 2014. It is a party to 2 conventions that I will speak about today and 1 further convention. So it's a party to the Hague Evidence Abroad Convention, the 1970 Hague Evidence Abroad Convention, and the 2005 Hague Choice of Court Agreements Convention. I'll speak about both of those today. There is a 3rd convention to which it's a party, the 1980 Child Abduction Convention, dealing with the well-being of the child. Thailand has applied for membership in the Hague Conference. It applied for membership on the 4th of March 2020. Typically, membership will take about 6 months to process. So 6 months from the 4th of March 2020 is roundabout now, September 2020. So I fully expect that Thailand will become a member of the Hague Conference, perhaps in the course of this month. Currently, Thailand is a party to 2 Hague Conventions, both dealing with the well-being of the child, the 1980 Child Abduction Convention and the 1993 Intercountry Adoption Convention. Finally, Vietnam has been a member of the Hague Conference since the 10th of April 2013. It is a party to 2 Hague Conventions that I will be speaking about this morning. That is the 1965 Hague Service Abroad Convention and the 1970 Hague Evidence Abroad Convention. It is also a party to the 1993 Hague Intercountry Adoption Convention. So in short, if we take Thailand as now a member of the Hague Conference, it's about 50-50. Half of the ASEAN countries are not members of the Hague Conference, the other half are. But if we include as having a relationship with the Hague Conference those countries which are a party to at least one Hague Convention, then the situation is that 7 out of the 10 ASEAN countries are a party to the at least one Hague Convention or a member of the Hague Conference, and there are only 3 ASEAN countries that have no relationship at the moment with the Hague Conference at all. That's Myanmar, Laos, and Indonesia. So that's by way of summary of the position in ASEAN in relation to the Hague Conference and the Hague Conventions. Let me now go to the second part, and let me deal with Hague Conventions on Legal Cooperation. There are 4 conventions that I would like to focus on. There are approximately 40 Hague Conventions and 1 soft law instrument, but I would just like to focus today on 4 Hague Conventions. These are multilateral treaties that are all currently in effect, and let me just go through them one by one. I will state briefly what they're about, and I will state briefly how they might be adopted to the COVID-19. In other words, what are the COVID-19 implications of the particular convention? The first one is probably the most popular of all Hague Conventions. It's the 1961 Hague Apostille Convention that drastically reduces the amount of legalization, authentication, or notarization which a quote-unquote public document needs before it can be produced in one contracting state. So, for instance, if you have a public document in the Philippines, it can be produced in all other contracting states of the Apostille Convention with a minimum of authentication. One stop, one place, you go to what is called the competent authority in the contracting state, have your public document authenticated, and it will be taken as authentic in all other parties to the Hague Apostille Convention. Currently, there are 118 contracting states to the Apostille Convention. So that's quite a large number of jurisdictions around the world. What about the COVID-19 implications? Well, I personally had a recent experience about this. As our moderator mentioned, I'm at the moment living in Japan where I'm teaching, and I've had to have a document authenticated for the purposes of use in Hong Kong. I can't travel to Hong Kong to sign the document in front of the relevant parties because of the travel and quarantine restrictions. So I would have to go to, in the normal course of events, I would have to go to several bodies to notarize, to authenticate the document. But since Japan is a party to the Apostille Convention, and since Hong Kong, through the PRC, through mainland China, is a party to the Apostille Convention, I was able to arrange, or I could arrange for authentication of my document. I signed the document in Japan, have it notarized, and then get it, attach an apostille to it, and then send it to Hong Kong. That's the way the Apostille Convention works. Now, for COVID-19, the Hague Conference has a special program, which it calls the EAPP, Electronic Apostille Program. So that gives an electronic apostille, not a piece of paper that you stick on to a document, but an electronic document. Your document is electronically authenticated. Now, it seems to me that one of the things that can be done for COVID-19 to make life convenient for users like me of apostille would be to have a completely automated system so that you can apply to the relevant authority, the relevant repository of a document in a contracting state. You can apply by internet, by email, to have a public document drawn from their database and then authenticated. an apostille attached to it and then sent by internet to the relevant other contracting state for use in that other contracting state. The system, the EAPP, the Electronic Apostille Program, can be developed, it seems to me, to deal with the difficulties of COVID-19. We cannot travel. We have quarantine and other restrictions. This way, we can do everything from the comfort of our home. That system needs to be developed, but I don't think there is anything technically difficult about it. The second Hague Convention that I would like to deal with is the Hague Service Abroad Convention, the 65 Hague Service Abroad Convention. It provides for court documents issued in one contracting state to be served in another contracting state through a central authority. There are 78 contracting states currently to the Hague Service Abroad Convention. What about the COVID-19 implications? Well, my suggestion here is that we can develop systems within contracting states for the effecting of service electronically. Nowadays, most service is still effected by hand, by post, in person, face-to-face. But COVID-19, the demands of social distancing, the problems of travel restriction and quarantine suggests to me that for ease, to make life easier for everyone, for the ordinary citizen in a contracting state, one can develop electronic technology for effecting service. That means that service can be effected quickly, instead of taking at least a month, 28 days or more, quickly and effectively. What about the 2005 Choice of Court Agreements Convention? That is the fourth. Well, sorry, let me backtrack a little. Let me deal with the 1970 Hague Evidence Abroad Convention. That enables evidence to be taken in one contracting state with a view to use of that evidence in judicial proceedings relating to civil or commercial matters in another contracting state. Currently, there are 63 contracting states to the Evidence Abroad Convention. The COVID-19 implication is similar to that with the Service Abroad Convention. Can we use remote technology? Can we harness remote technology so that evidence can be taken abroad with a minimum of bureaucratic formality? Nowadays, in arbitrations and in court hearings, including court hearings in my court, the Singapore International Commercial Court, evidence is taken remotely through applications such as Zoom. This is the commonplace today as a result of COVID-19. It has wonderful advantages in terms of cost, affordability. You don't have to travel. You don't have to pay for your accommodation in another country. I do not think it loses immediacy. You can have protocols so that evidence is taken properly from in one country to another. It seems to me that it also lowers the carbon footprint. It helps our environment. So I anticipate that even after we get through COVID-19, evidence will continue to be taken through Zoom, not just in arbitration, but also in litigation, in legal proceedings, in court proceedings. Thus, the Hague Evidence Abroad Convention can be harnessed. Platforms can be built or developed to enable evidence to be taken abroad using remote technology. Now, there's one small problem. With civil law countries, as opposed to common law countries, quite a number of civil law countries, Indonesia may be one example, regard the taking of evidence for use in a foreign court. They may regard the taking of evidence in Indonesia, even remotely, as a breach of Indonesian sovereignty. So there may be problems in some civil law jurisdictions about the taking of evidence abroad. So that if, say, one takes evidence for use in the UK, one takes evidence from an Indonesian witness using Zoom, one may still have to apply for permission from the proper authority in Indonesia in order to do so, because otherwise, technically, as a matter of Indonesian law, it may be regarded if you do it without permission, as an affront to Indonesian sovereignty. So that sort of procedure for taking evidence remotely via Zoom would still have to be developed, discussed, and developed. Finally, as I mentioned, there's the 2005 Hague Choice of Court Agreements Convention. That ensures two things. One, the court designated by the parties in an international commercial agreement, and no other court will hear a dispute arising out of a particular relationship. And two, the judgment of the designated court, the court designated by the parties in their international commercial agreement, will be recognized, enforced. The judgment of that court will be recognized and enforced in all other contracting states. Currently, there are 32 contracting states to the Choice of Court Agreements Convention. What about the COVID-19 implications? It seems to me that the implication is that it will enable, if we can use this in COVID-19, it will enable mutual recognition and enforcement of judgments in relation to international commercial contracts with a minimum of bureaucratic formality. Using remote technology, again, harnessing remote technology, parties can appear before the designated court, make their submissions, etc. So it provides a convenience. There's not much that needs to be done to improve it for COVID-19. It seems to me that it's ready and can be. Now, there is a lot more information on COVID-19 implications of the 4 Hague Conventions that I've identified. For that, you can look at the website of the Hague Conference, www.hcch.net, and the Hague Conference has itself developed a convenient COVID-19 toolkit that discusses how various conventions, including the ones that I've just mentioned, can be used in the COVID-19 period. So that's an introduction, very quick, to the Hague Conventions. Let me now move to what ASEAN countries can do. And my suggestion is very simple. ASEAN countries can simply adopt the Hague Conventions, the 4 Hague Conventions that I've specified. They can adopt them as a package in order to have a convenient legal infrastructure for the ASEAN economic community. They will facilitate greatly the ease or doing business amongst ASEAN countries. It can adopt it within ASEAN, and it will have the extra benefit in adopting it for ASEAN in having other countries, other contracting states take advantage of it, and ASEAN countries, including hopefully Indonesia, taking advantage of those conventions in relation to service abroad, in relation to the authentication of documents, in relation to the taking of evidence abroad, in relation to facilitating the recognition and enforcement of foreign judgments. So my suggestion is to adopt it. Now, a few years ago, many years ago, there was a talk initiated, I think, by Vietnam about having a mini Apostille convention or mini conventions just applying, mini Hague conventions just applying to ASEAN countries, just applying within the ASEAN region. I suppose that half a loaf is better than none. It may be that as an initial step, ASEAN countries, to become comfortable with the Hague Conventions, would like to have some sort of system based on the 4 legal cooperation conventions that I've just identified, some sort of system infrastructure based on that, applying at least to ASEAN countries. Once ASEAN countries become accustomed to that, then perhaps they can open up and then join for the purposes of the entire Hague Conference community, the many contracting states that are also parties to this convention. Let me now end with a few remarks on FDI implications. And you might ask, well, what's the purpose of all that? It's very nice. It's very nice to have all these conventions, but why? At the moment, if we look at COVID-19, what has COVID-19 brought about? It has brought about travel restrictions. It's brought about quarantine restrictions. The likelihood, unfortunately, is COVID-19 will be with us for some time yet. It's not going to go away. even if there is a vaccine developed early next year, it will take time to have sufficient people vaccinated all over the world. Some estimates currently say, well, that won't happen until at least 2022. So it'll be with us for some time. In the wake of COVID-19, there is economic recession. There's unemployment, there's financial crisis, breakdown, meltdown, left, right, and center. ASEAN countries will be competing for scarce foreign direct investment amongst themselves and with other countries. We'll be competing to invite those. Now, different ASEAN countries will have their different economic policies. I know, for instance, Indonesia is considering what it can do to improve FDI in Indonesia. But certainly one of the factors that foreign investors will be looking at is ease of doing business. Probably there will be a mistrust, for instance, of each other's legal system. The Indonesian party will say, I don't trust the foreign legal system. If you're talking to a joint venture partner, you say, I don't trust the court system in your country because it will favor you. The foreign joint venture partner will say, I don't trust the Indonesian court system because it will favor Indonesians. So probably they will go for some neutral third-party country. They will agree that in their international commercial contract. But what's to guarantee that the decision of that court will be enforceable within, say, Indonesia or within the country of the foreign joint venture partner, let's say another ASEAN country? Joining the Hague Choice of Court Agreements Convention or having a similar convention amongst ASEAN countries to deal with investments within ASEAN countries will at least give assurance of that. Take another matter, document authentication. To help the ordinary citizen, and Indonesia has been sending quite a number of its domestic workers abroad, in terms of authenticating documents, it pays, it seems to me, to join the Apostille Convention or to have some mini Apostille Convention, at least for the purposes of ASEAN countries, in order to help the ordinary citizen. You can't travel around that much nowadays under COVID-19. A lot will have to be done electronically. So what the governments can do in ASEAN countries is provide electronic facilities in all areas of a country, since, say, for instance, in the Philippines or Indonesia, which are basically archipelagos, even in remote communities there, so that people can connect, have their documents authenticated, and life can go on as much as possible as normal without the need to go to Jakarta, without the need to go to Manila to have documents authenticated. An electronic apostille program of the sort similar to what The Hague is talking about, EAPP, would be of great assistance in facilitating business. Service abroad. Well, the more business you have, the more foreign direct investment. Unfortunately, a corollary of that is the more disputes there will be, the more commercial disputes. Hopefully, these will all be resolved through, say, international commercial mediation. But it may have to come to court. In that case, a system whereby you can serve abroad and be served from abroad, a system whereby you can take evidence abroad and whereby evidence can be taken from your country for use abroad, would make a country greatly attractive for foreign direct investment. The foreign investor will say, well, we can designate a foreign court, a neutral foreign court to hear our cases. Service is no problem because of some system of electronic service. Taking evidence is no problem because, as we now know, we can take evidence remotely and problems of sovereignty can be resolved, can be dealt with. We know how those will be handled by a particular country because it's made that clear by having a particular convention dealing in particular with electronic means of taking evidence or electronic means of service. We can deal with that. So in those circumstances, it will enhance the attractiveness of a country for FDI. Indonesian companies do a lot of investments in other ASEAN countries. It will make Indonesian companies more willing to invest in other countries. It will make other countries' investors more willing to invest in Indonesia. That, along with whatever package of economic incentives Indonesia or other ASEAN countries develops, that will make a country competitive for the scarce foreign direct investments that will be around at the time of the post-COVID-19 era. I've nearly finished my presentation. I only have 1 minute left, so I would just like to thank Brawijaya University. I'd like to thank the Dean for inviting me to give this presentation this morning. Thank you very much.
Thank you very much, Professor Anselmo Reyes, for your interesting presentation on the Hague Convention. A little bit information about Professor Reyes. He was former head of the Hague Convention, Regional Office of Asia Pacific in Hong Kong until 2019. Okay. So now the next speaker is Dr. Eliezer Sanchez Lazabalet. Let me present his short bio briefly before he delivers his speech. So Dr. Lazabalet got his PhD from University of Newcastle, Australia. And then at the moment, he is also teaching or become a lecturer in the Newcastle Law School. Basically, his specialization is about contract. So after this, we will listen to his presentation, very interesting one, about contract with foreign elements. So now it is time for Dr. Sanchez Lazabalet to deliver his presentation. So Dr. Sanchez, if you like, you may start sharing your PowerPoint from your laptop. Ready? Okay, now time is yours. Thank you. Could you please unmute, sorry, your mic, or the host, could you please help him? The host, okay.
Okay, you're unmuting me on my laptop. Excellent. Well, in this laptop, I'm also sharing a slide, but if you can see it, if not, no problem at all. Well, my paper I'm going to share with you today is called Presumption of Similarity in the Law of Contracts with Foreign Elements. And is divided into 7 different parts. First, I will share an introduction. Then I will talk about foreign law, judicial notice, and the presumption of similarity. In the third part, we're going to talk about the presumption of similarity in Australian courts. In the fourth part, we're going to talk about lessons from the presumption of similarity. The fifth part, we're going to talk about displacing the presumption and applying foreign law to a contractual obligation. In the sixth part, I will talk about final considerations, and then I will conclude with a short summary. So introduction, private international law is more relevant than ever in an age of globalization and cross-border transactions, despite renewed nativism in politics, economics, trade, and law. The COVID pandemic has provoked mixed feelings towards stronger national states and competing but interdependent hegemonic economies. What is undeniable is the significance of international and comparative skills for legal practitioners and students. Let me see if I can avoid this. There is a delay here. Okay, comparative skills for practitioners and students as a key component of the legal system. This matter has been raised by the Australian Law Reform Commission before, and in the recent past, by the Law Society of New South Wales in its Future of Law and Innovation in the Profession report. This paper is concerned with private international and comparative law issues arising from the application of foreign law in Australian courts. In particular, this paper focuses on the law applicable to contracts with foreign elements. This paper shows that despite legal systems' idiosyncrasies, they are not different so as to justify the default operation of the presumption of similarities when parties fail to prove foreign law at the complete satisfaction of the court. Actually, the development of private international law is hampered by a limited understanding of foreign legal systems by practitioners. Parties' economic freedoms, and in particular parties' freedom of contract, are restricted by the lack of familiarity of legal practitioners with foreign legal systems. Parties, even with able legal advice, may choose the law of a neutral third state legislation to govern the transaction. But this is frustrated when in legal proceedings they need to rely on litigators who are experts only on their municipal legal system. It is for the litigator to persuade the judge or of the benefit of a foreign legal system with which they are completely unfamiliar. It is for them to instruct and examine the expert witness entrusted with enlightening the court on how to apply the foreign law chosen by the parties to govern their contract. On the other end of the spectrum, courts are also limited in their task to deliver fairness of the case and promoting quality in the law. This is more so if, when applying foreign law, courts are insufficiently informed on the legal nature of such rules by the expert witness founded by the parties themselves. In Australia, the law governing the substantive obligations under a contract with foreign elements is the proper law of a contract. The proper law of a contract is the domestic law of a legal system parties choose at the time of contracting. Parties can make their choice of law known to the court by means of an express choice clause, in which case factual connection with the chosen legal system is not required. The principle of parties' autonomy lies at the base of the proper law of the contract. However, Australian courts will not enforce an express choice of law if parties try to evade the application of the law of the forum, the Australian law, that would have applied but for the parties' choice. Where there is not express choice, the court will enforce parties' inferred choice by determining their common intention to have their contract governed under a particular legal system. Parties' inferred choice is determined on the basis of the putative proper law. Parties' express or inferred choice of law can be overridden by mandatory rules of the forum, as is the case with the Insurance Contracts Act and the Australian Consumer Law, amongst others. In the absence of express or inferred choice, courts will look for the system with which the transaction has its most real and closest connection. The determination of the proper law should be made by paying attention to the circumstances at the time of the contract formation. In the Australia legal system, question of contract formation, in particular acceptance, are determined according to the putative proper law had the contract come into existence. But in China Solar Incorporated and Jasmine Solar Proprietary Limited, the court applied the Lex 40 following the precedent in Oceanic Sunline Special Shipping Company Incorporated and Fdi to determine questions of consensus and ad idem. Let's move on to the second part. We're going to talk about now foreign law, judicial notice, and the presumption of similarity. In exercising their contractual autonomy, parties resort to foreign law, which does not fall within the court's judicial notice or knowledge, also known as the juris novit curia principle. The local judge is under no obligation to know foreign law. Therefore, foreign law becomes a question of fact that the party relying on it has the onus of proving it. If the party asserting a right or a defense under foreign law fails to discharge their onus of proof, the court will adopt a presumption that the foreign law is similar to the local law of the court. In conflict of laws jargon, the court will adopt a presumption that the lex causa is similar or identical to the lex fori. In the recent past, the relevance of this presumption has been challenged in Australia in Oceanic, the case I just mentioned, and also in another case, Akai Proprietary Limited and the People's Insurance Company Limited. Since more fundamental issues such as the very existence of parties' consensus to adopt a foreign law have left the door ajar for applying lex fori. In relationships with foreign elements, a party in asserting rights under foreign law has the onus to demonstrate the existence, or better said, the legal nature of the rule of foreign law supporting their claim or defense so as to achieve fairness in the particular case. In Australia, this is operationalized by the law of evidence, by considering law as a question of fact rather than a question of law, remaining the former outside the remit of judges' notice or knowledge. Parties claiming foreign law can rely on evidence tendered by an expert witness with the purpose of enlightening the judge or the legal nature on the legal nature of the foreign rule applicable to the case at hand. Reliance on such presumption differs from jurisdictions where the judge have to apply ex officio the lex causa or lex causa. Other jurisdictions operate under an eclectic rule where both parties have to adduce foreign law supporting their claims, and the local judge also has to apply the foreign law. The problem arises when the judge is not satisfied that the party has discharged such onus of proof, therefore leading to the application of lex fori. The logical expectation seems to be that if the alleging party is better off under foreign law, they should have an interest in rebutting the presumption. The consequence would be that if by failing to displace the presumption, the party would suffer the damaging consequence of having their case decided under the lex fori. But in reality, what happens is that parties inadvertently or deliberately fail to prove foreign law as part of their claim or defense, therefore relying on local law to support their cases. At the end of the day, the local law is the law with which litigators and judges are more familiar because of economies of scale and specialization. Other jurisdictions apply a more serious consequence to parties' failure to prove foreign law. Parties' claim should fail if evidence of foreign law is insufficient. In the third part of this paper, I talked about the presumption of similarity in Australian courts. In practice, applying the presumption of similarity is not as clear as it looks in theory. For instance, parties might not tender evidence of foreign law. In World of Technologies, Proprietary Limited and Tempo, Proprietary Limited, the court applied lex fori, Australian law, instead of Chinese law to determine if a purported exclusive distribution certificate supported applicants' contractual rights to exclude the respondent from selling the same product in Australia. Here, Justice Jessup considered the question of which was the applicable law to determine if a contract had come into existence between the applicant and the manufacturer based in China. In doing so, Justice Jessup referred to Oceanic, a case I just mentioned. It was a case of a stay of proceedings on the grounds of forum non-convenience in favor of the Greek jurisdiction. In Oceanic, Justices Brennan and Godron proposed that the question of contract formation should be determined under lex fori, New South Wales law. Justice Dean agreed with Justices Brennan and Godron, but dissented, despite agreeing with the majority. Justices Brennan and Godron, but they followed the lex loci contractus. Justice Dean agreed with Brennan and Godron, but followed the lex loci contractus, New South Wales law. Justices Wilson and Toohey dissented, despite agreeing with the majority that the contract was entered into in New South Wales. These last two judges followed the proper law of the contract as the law with the most real and substantial connection, the lex causa or Greek law. Notwithstanding that, in the above-mentioned case of World of Technology, while neither party adduced evidence of Chinese law, the lex loci contractus, Justice Jessup applied the lex fori to find out whether a contract came into existence. The presumption of similarity has been subject to qualification what it is not reasonable to presume that the lex causa is identical to the lex fori. In Dunbar and Dunbar, Justice of Appeal Hayden, as he was then, with Chief Justice Spiegelman and Justice of Appeal Scheller concurring, that a court may refuse the application of the presumption of similarity between foreign and local law. Justice of Appeal Hayden argued that, despite limited evidence that German taxation law was different to the Australian law, the law of capital gains tax could not be assumed to be premised on broad principles of the German civil as a civil law legal system. Therefore, it wasn't even similar to Australian tax law. Thus, in the face of insufficient evidence as to foreign law, Australian court has applied lex fori to uphold a contract where it seemed fair to do so. In Commonwealth and Mills, the Supreme Court of New South Wales, in appeal, held that Cambodian law, the lex causa, had the most real and closest connection with the contract due to the nature of the service provided. In spite of this, the court deemed fair to uphold the contract for medical services under the lex fori in the face of insufficient expert witness evidence of the perplexing Cambodian contract law. The use of the presumption of similarity seems sidelined by more substantive questions concerning whether there is a consensus ad idem rather than what is the proper law of the contract. More recently, in a case I mentioned, China Solar, it was held that the proper law of the contract was the law of New York. However, in finding whether there was a consensus ad idem, the court applied lex fori instead of the putative proper law. The full court made clear that finding whether parties reach a consensus ad idem was a necessary condition to the existence of an agreement that otherwise may be governed by the lex causa. The fourth part of this paper, I'm going to share some lessons from the presumption of similarity. Criticism of the presumption of similarity argued that the presumption is detached from reality, as legal systems are not identical to each other. Attacking a presumption as unreal is an oxymoron to my mind. The presumption of similarity is a legal fiction that overcomes the problem of ignoring the operation of foreign law. The aim of a presumption is to induce the existence of an unknown fact by means of a known fact. Likewise, a proposed rule prescribing the application of lex fori by default unless foreign law is proven also contradicts itself. Again, if foreign law as a fact is not proven, it doesn't make foreign law less real or inexistent. To my mind, the problem with transactions governed by foreign law seems to suggest the need to equip legal practitioners with basic comparative skills. In doing so, they will be able to navigate and plead foreign law confidently while being able to strategize and control the effects of expert witness deposition. We do not see from the court cases that there is unfairness or injustice created by the presumption of similarity. To the contrary, case law seems to show that courts can arrive at a satisfactory outcome by applying the law of the forum, even when ignoring the actual effect of foreign law in the case. This seems to be in line with the requirements of justice and fairness of the case as per conflict of law rules. In the fifth section, we're going to focus on displacing the presumption and applying foreign law to a contractual obligation. In the matter of Bonacina, a public instrument acknowledging a debt entered into in Italy was considered to be enforceable under the lex causa, Italian law. Lex causa, Italian law. This is an English case where the Chancery Division of the Court of Appeal reversed the primary judgment that had dismissed a debt for lack of consideration under Lex 40, the English law. According to expert witness, Italian advocates, as described by the judgment, the instrument was enforceable under Italian law despite lacking consideration. This argument was supported by the authoritative doctrinal writings by A.V. Dicey, arguing that the transaction was based on continental law where the doctrine of consideration did not have application. To me, this is not quite accurate, since the functional equivalent to consideration in civil law jurisdictions may be found in the contractual cause and the counter-performance in bilateral contractual obligations, just to name a few examples. Italian experts argued that the transaction was made by private written instrument. The functional equivalent of the Italian term scrittura privata, which requires authentication by a public notary to be enforceable under an executive procedure. There was also expert witness reference to the effect of the written instrument as a public instrument, which was contradictory. It results from its recording in a public registry, bestowing erga omnes effects upon it. It has legal effects against third parties. To me, the very fact that the instrument is a public instrument under Italian law, it brings the instrument under a category functionally similar to a deed. This means that the instrument does not require consideration under English law either. It is a formal contract, not a simple contract in want of consideration. As per Lord Justice Kennedy, the obligational effect of a written instrument should be determined under the lex causa as a proper law of the contract, Italian law. The Lord Justices had a strong intuition of fairness in the case applicable to the unilateral promise to honor a debt, which would have been similarly attainable by the correct application of the lex causa if they counted on reliable expert witness assistance. Well, now I will expose my final considerations. I would argue that a court in a civil law jurisdiction would have arrived at a similar outcome as to the contract formation issues in the Australian cases above. However, it is important to bear in mind that the question of contract existence is not a question of substance in civil law legal systems, but a question of evidence. Hence, it should be left to the lex 40. The distinction between conflict rules regarding the application of foreign law in civil law and common law legal systems is misleading. Considering foreign law as a question of fact outside judicial notice portrays common law jurisdictions are purely adversarial, whereas civil law legal systems as inquisitorial. The procedural principles informing civil law legal systems are not inquisitorial everywhere at all times. This is also true of common law legal systems where even the adversarial aspect of the proof of foreign law and its consequence are colored by inquisitorial instances. A more accurate picture is that of the status of conflict of law rules. In civil law jurisdictions, conflict rules are of public order informed by public policy. In civil law systems, foreign law is a question of law falling within judicial notice, the juris novit curia principle. While parties have the obligation to support their allegation with a corresponding legal rule, judges have exceptional powers to resort to expert witness and to conduct their own investigation into foreign rules. This inquiry does not differ from the judge's inquiry in Danberg and its ratio. Considering foreign law as merely a question of fact militates against revision powers in appeal, jurisdiction, or judicial review. Nonetheless, this view should not be taken as if civil law conflict rules do not displace foreign law even when cogent reasons prevail, such as public policy reasons or an unknown foreign legal institution functionally ascertained. My short conclusion is that, well, this paper has provided an insight into the operation of foreign law in the adjudication of contractual disputes with foreign elements. By considering the rules with which a court determines the applicable law to contractual disputes, this paper argued that so long as the task of adjudicators is guided by principles of justice and fairness of the case, we might expect similar outcomes in applying either foreign or local law. Nonetheless, an aspect that requires attention is that of practitioners who appear as expert witness to inform the judge on the legal nature of the foreign law. The role of legal education is key to equip future practitioners in upholding parties' autonomy and freedom of contract by strategically articulating the chosen foreign law into legal proceedings while controlling the outcome of expert witness evidence. Well, thank you so much for your attention. Thank you so much for the invitation to speak in this conference. Thank you.
Okay. Right. So, thank you, Dr. Sanchez, for your interesting insight on the law of contracts with foreign elements. And then, so now we reach the third speaker, Dr. Ricardo Antara. Let me briefly present his resume. So Dr. Ricardo Antara got his PhD from Brawijaya University. And at the moment, his position is the secretary of the Department of Law of Brawijaya Law Faculty. And he published several articles and books and research, and also teach mostly in the field of banking law and financial law. So it is very interesting that today we are going to hear from him about crypto contract. So now let us listen to Dr. Dewantara's presentation. So Dr. Dewantara, if you like to share your presentation from your computer, just do so. Okay, I give you time until you finish. You are ready. Okay, good. So now time is yours. Thank you.
Okay, thank you, Dr. Afifa, for the time that given to me. Okay, this morning I will present my research paper. It's about the deconstructing the crypto contract, the legality, and the dispute settlement. I will try to slide so. The philosophy of the internet. All people in this pandemic era, in the COVID-19, they have a lot of questions. What is the thing that can help us so we can still physical distance? So the question is, the first is, what is the most important technology for the last 40 years? The answer is the internet. And then, what is the most important technology in the next decade? The answer is still the internet and the artificial intelligence. And the third one is, what is the technology that has evolved in a surprising way? And then the answer is still the internet and the artificial intelligence. So with that question, we have to know that the internet is still here. So the philosophy is the internet is still here and will continue to grow with the new application and technology because all of the people need it. And then the internet will have still day by day, they will have the new innovation for the persons. especially in this pandemic era. So the internet will always still trying to find what is the right governance model. So the government will have the newest how they can regulate it with the development of the internet and the development of the information and technology. And then the last, what is the right business model? With the electronic commerce, with the smart contract and all of the electronic contract, they use how to find the business model that they can meet each other without the traditional way. So the internet is still the answer. So if I want to use the law philosophical approach about the internet, I think it is focused on two words. First is there, and the second is called being. So in law, which has an impact on the law, is namely, first is the legal relation. Because the cyberspace is essentially a form of networking relationships that create the interconnectedness and interdependency. The second one is called the person or Recht person. We say that this is as a legal subject because the cyberspace, they are the fundamental change about the self and identity. And the third one is the place, because in the cyberspace, it still needs the term of the place, but sometimes the place is still imaginary space that impedes of the computer. Somebody say that is the cryptography. So the computer is very different from real space and is very limitedly by the geopolitics and law. So what is the another's, if we want to say in the contracts, we call it the smart contract. So I will tell you a brief description about what is the crypto contracts and what is the blockchains. Before I tell you about the crypto contracts, I want to say about what is the smart contracts. The smart contract is based on the research paper of the Dick Szabo. You say that smart contracts are the self-executing electronic instructions that drafted in the computer code. This allows of the computer to read the contract, and in many cases, it evaluates the instruction, the smartness of the contract. Variation of some smart contracts is such as the transaction processing system that compute the daily payments and receive for financial institutions that have been existed. The concept has taken on new relevancy and possibilities. However, with the advent, maybe we can say Ethereum or the Bitcoin or another cryptocurrency and its underlying technology, and it's called the blockchains. The smart contract is self-execute the stipulation of an agreement when predetermined conditions are triggered. So the parties have signed the smart contract using the cryptographic security and deploy it to a distributed ledger, or we call it the blockchains. So what is the objective of smart contract? First, condition payment terms, liens, confidentiality, and enforcement. And the second one is to minimize the exceptions. What some exception, both it's for malicious and the accidental. And the third one is to minimize the need for trusted intermediaries. And some scholars say that we don't need third party anymore. And some scholars say, he called Richards, he said that we don't need what we call it the arbitration or the court anymore. Why? Because the smart contract is related with the economic goals. What is first is to lowering the fraud loss, so we don't even have some fraud again. And the second one is the arbitration enforcement costs, and the another transaction cost. I'm sorry, Professor Anselmo, but this is the person says, some scholars says about the smart contract. And then what is the types of the smart contract? Smart contract, the first one is say the basic token contract. This is the contract that use the traditional token for the base of the contract. And the second one is said that the crowd sale contract. This is the contract that uses the crowdfunding, how the person that do not meet each other, but they can meet only in the cryptography. And the third one is called the mine table contract. This is from the word mining, because the person that use the cryptocurrency, they will use that the person says like the mining in the miners. And the fourth is called the refundable contract and the terminable contract. The refundable and the terminable contract is always used in the electronic commerce. So what is the crypto contract? The crypto contract is called the basic token contract, the crowd sale contract, and the mineable contract, but sometimes it can use the refundable contract. So the crypto contracts that use the smart contract, which are a form of electronic agreement that is closely related to the blockchain technology. What is blockchain? I will explain it after this session. If the smart contracts are going to become the important business tools, it additionally, legal and regulatory frameworks may be necessary to mitigate any negative impacts. And maybe it will facilitate the full achievement for their potential. I take the Tapscott and the Tapscott from his paper. He said that parties only sign the crypto contract using the cryptographic security and deploy it into the distributed ledger or the blockchains. And Ricardo Antara said that if the blockchain will allow the financial transaction without the banks, with the financial institution, so the crypto contracts may lead the contract that no longer need courts to enforce them. So this is I take from the first frontal attorneys. He said that why you cannot cheat Bitcoin. So why we do not need the court anymore. They say that first, if we have some description, everybody said that they are working on the block 91. So all of the miner wants to, after the transaction, is they will use the block 74. So if you want to make, or if the hacker want to change the block, or they want to take, or they want to make some fraud, they must fraud not only the block 91, but they must use not only the 91, but all of the block, they must hack that system. This is called the blockchains. So the crypto contract not only use the blockchain, but the crypto contract is used the escrow agreements. What is the escrow agreements? If the money held in escrow is until the performance is met. When the performance is validated, so the money is released. But if the performance is not validated, the money cannot release. So it can be regulated by an unbiased party, which only seeks the objectively right answer to divide or outside influence. So how the blockchain and the smart contract is happen? First, we can authenticate the party identities. Maybe if you have the money or the intrinsic money, we say that this is your money. But when your money is dropped down in the ground and another people take, or Dr. Afifa take the money, you cannot say that that's my money. No, Dr. Afifa can say that, no, this is not your money because your names was not registered in this money. But in the crypto contract, there was a registered money. So the people can authenticate the party identities for the ownership of the assets, and they can claim of the rights. So the smart contracts not only register your name, but it can do, or it's always need, that is called digital signatures for the private cryptographic keys that held by each party to verify the participation and assent to agree terms. So we have to know that this is the crypto contract is still need that is called the mutual assent. And then we can access or refer to a set of the information or data to trigger the actions. So the smart contracts is a mutually agreed upon that network authenticate reference data provider that potential to party. This is a source of information to determine the action and or the contractual outcomes. For the example, maybe the commodity prices and then the weather of data, the interest rates, and then maybe for some insurance that or and even the occurrence. And then it can self-execution. What is the self-execution? So the crypto contract that they can use the smart contract, it can automate it for the execution processes. So the smart contract will take some action, such like some dispersed payment without the further action for the counterparties. So if the seller meet the buyer, they will not meet in the contract. They do not need, so I want to disclose, but the contract is can self-execution without the permissions of the parties. So the crypto contracts is a step beyond the typical of the electronic contract that in the actual agreement is embodied in the computer code of the cryptography, rather than the English or another traditional language. So the financial institution have been using some automated computer protocols to settle the transaction without human intervention for this several decades. So the contract is a legally enforceable promise or the promises. So how it can be the enforceable? The contract must meet a number of the conditions of the imposed by law, such as the multiple parties, the capacity of the parties, the mutual assent, and the considerations. So one of the initial questions that regarding on the smart contract is whether they are really contract, or the crypto contract is a contract that is legally enforceable promise or the promises. While in the general, a contract maybe we can use the oral, that the certain contracts must be in tangible form in traditional way. And as a practical matter, most business that related to contracts are in a tangible form, whether in traditional written documents or in electronic form, such as in electronic terms and conditions. We have been in Indonesia, we have been regulated in Information and Technology Act. In order how to be enforceable, a smart contract will have to meet all of the traditional requirements of the failed contract. One of the areas that may be especially tricky for a smart contract is showing the mutual assent to the contract. Mutual assent must be manifested by making some promises and or rendering the performance. The manifestation of the mutual assent may be written or spoken, but as noted above, some contracts must be in the tangible form. And then the manifestation of the mutual assent is traditionally based on the concept of offer and all of the acceptance by the parties to the contract. The several recent cases have explored what is the concept of the contract formation in electronic age, but have consistently been falling back to the traditional principle of the contract formation. So the contract, what is the typical of the crypto contract? The typical of the crypto contract is called the click wrap or the prose wrap categories. The click wrap agreement that the website must that the user must be affirmatively click on the box that he agrees to the term. So if you not click on the box, you cannot agree or you disagree with that agreement. And the browse wrap agreement is the term that are posted on the website and is do not require affirmative assent from the users. So we have to note that without the actual notice of the contractual terms, so we can know that in this browse wrap or in the clicking wrap, we have to note that the contractual terms that the user must be put the inquiry of such terms. This typically it needs some requires of the terms that cannot be conspicuous, and it can be the effective notice that be given that continues of the website that will bind the user of the terms. So I think this is the clear from this line of the cases that the enforceable of the crypto contract must have clear record of the mutual assent of the terms, such as by the clicking of the agree button, or it must clearly to disclose the terms to the contracting parties. So the courts have been more likely to uphold the agreements to meet these conditions. In the recent case, a court found manifestation of the mutual assent in an online transaction when three factors were present. First, a conspicuous notice of the terms that used for an online transaction. Or maybe the second one, an express of warning that proceeding the further with the transaction will bind the party up to the terms. And third is the express of the agreement by the user to the terms and the condition at the time of the account creations. So in my slide, typically I say that the courts have to require a showing of the actual notice, So without the actual notice, the user must put on the inquiry notice of such terms. So I have been saying that typically it needs some requirements. So the people said that if the court found a manifestation of the mutual assent in online transaction when three factors were present, so it will versus the immutability of the blockchains. And then, how about in the commercial law that have been, we have been known that Indonesia is still use the commercial law, but they are prohibited for the use of the cryptocurrency. In the Currency Act, number 7, year 2011, say that the currency that can be used in Indonesia is only rupiah. We cannot use the Bitcoin, the Ethereum, or somebody said that in Bali, they have been produced some coin that it's called the Bali coin, so we cannot use that. But the commercial law allows for the people to use that. And some of the commodity in the share regulation, they say that they can use the cryptocurrency. So we can say that commercial law that allows a court to deny the enforcement to certain other ways for the valid legal agreements based on the public policy ground, because the people need. So maybe we can use some review, or we can do some the subsequent of the non-enforcement of the smart contract after it is created. Maybe it will be the odds with the immutable character of the blockchain. One of the most widely heralded features of the blockchain is called immutability. What's immutability? It's the forming an inviolable that record from the transaction. So if the crypto contracts make the mistakes that have been made in some connection, or maybe it can be reversed by the court for the parties of the agreement, it seems unlikely that a lot of the financial institution, some regulators, and the government official, it will be embraced the technology that cannot be changed by the law. So how about Indonesia? In the Article 1, number 17 of the IT Act or the Information and Technology Act say that the agreement of the parties made through the electronic systems. They say that the crypto contracts in the law and regulation in Indonesia is included as an electronic contract because a smart contract is a contract that formed through any electronic system. What is electronic system? Is the system that uses the electronic ways to make the contract. And then in the Article 23 of the Financial Services Authority, we call it OJK, make some regulation in number 77 about the POJK.01 in 2016 about concerning about the information technology based lending and borrowing services, or the fintech regulation is regulated. Fintech operators can exchange data with the fintech or financial technology service support providers, which can be in the form of information technology, including big data analytic, aggregator, robo-advisor, or blockchains. So some scholars say this is the conflict of norm, because in the Currency Act it's really prohibited for the use of the cryptocurrency, but in the Financial Services Authority regulation said with another form of the contract, we can use the big data, we can use the aggregator, we can use artificial intelligence such as the robo-advisor, or sometimes we can use the blockchains. So how is the civil code to regulate this transaction? Maybe we can say that is the legality of the crypto contract. The civil code uses the term of agreement, but in the another laws and regulations, such as in the IT Act or Information and Technology Act, and the government regulation is used the term contract. But in electronic contract, and is equated with the agreement. So the contract of the electronic contract is equated as the agreement. And in the 1321 in the civil codes regulated that the agreement becomes invalid if the agreement occurs to the element of error, the coercions, or fraud. I think it can be the interpretation of the judge. And then in 3027 for the civil codes, basically everyone is competent in making agreement unless it is determined that they are not competent according to the law. So if the law says that the person is competent to make the agreement, so if the seller or if the buyer is competent to making the agreement, so it can determine that they are competent according to the law. How about the object if we use the cryptocurrency in the crypto contract? So if we use the cryptocurrency and the crypto contract in the 1337 in the civil code article, say that the smart contract are possible to be implemented as long as they do not conflict with this article. So, and then the existence of the arrangement regarding the electronic acts in international or in the Information and Technology Act in the Article 18 that defines the electronic agreement is agreement between the parties made through in an electronic system. So, however, it's not if the object is used the cryptocurrency and then it's all of the object can use in the smart contract. Maybe I have some example. This is the cube. Cube is one of the seller that use the electronic commerce in Singapore. Asian people, all of the Asian people, I think they have been used this cube. I take it from the Straits Times. the cube is used the escrow in the smart contract or the crypto contract to ensure the goods that will arrive to the buyer by holding and securing payment of the buyer. So the smart contract, before the buyer and the seller got the mutual assent, so it must be proved by the contract or the clause. So the proof of the goods that have been received by the buyer from the confirmation of receipt of the goods. So the buyer, they will not do the payment if the seller is not freight forwarder. So you will not do your payment before you accept the goods. And then the seller will not will not freight the forwarder for the goods before they receive the payment from the buyer. So in the smart contract, it can say that self-executable if the seller didn't freight the forwarder for the goods. So the seller will not do the payment after the smart contract is confirmation. So if the judge or the people or the parties will make the contract interpretation for this smart contract, we can say that in Indonesia, we use the 1342 in the civil code. The scholars say that this is the objective for the interpretation. The 1342, the article in civil code, say that in this article, if the agreement is unclear, the parties are prohibited from interpreting. So the parties cannot do the interpretation for the clause that have been do in the mutual assent of the crypto contract. If the parties have been clicking by the sources web, so it can say that they have been accept the agreement. So they cannot do the another interpreting.
Dr. Reka, I'm sorry.
I'm sorry, yes.
Yes, I think time is almost up for you. Could you finish your presentation in 2 or 3 minutes? Okay, thank you.
Okay, thank you, Dr. Afifa. Maybe in a simple way how to describe this. And then for the dispute settlement, we can say that in the Article 18 in the IT Act, it says that the choice of law for the parties that have the authority to use the law is the electronic transaction international made. But if the parties in a choice of law in international electronic transaction, so that law, it applies based on the principle of the private international law. And then how is the choice of forum? In IT Act, it has been says in the Article 4 and 5, it says that the parties have the authority to establish a court. But if the parties do not make the choice for a forum, it will be based on the principle of the private international law. So what is the principle? You have to know that we can say that this is used the lex loci contractus, or we can use the lex loci solutionists, or some theory is used the proper of law, theory of the contract. If the legal system is desire of the party, so it will not expressly stated for the surrounding condition. Or we can use the most characteristic for the theory connection, that the obligation to the fit most characteristic is to repulsion measures for the legal determination be regulated in the agreement. So what is the recommendation from my last presentation? First is the crypto contracts for the preserve the best features of the traditional contracts. It's including the ability of renegotiated in the future if necessary. So it will not be the immutability of the blockchains. And the specialization in smart contract technology will be needed to validate the smart contract in any litigation. including the verifying that the security protocols are sufficient to maintain the code that in its accurate human states. And the third one, the reformulation of the rules that will deal specifically with the mechanism of the contract formation, the enforceability, the jurisdictional issues, and the legal ethics that related to crypto or the smart contracts. Thank you. I think it's all. Thank you.
Okay. Yes. Yes. Okay, you already shared the screen. Okay. Thank you very much, Dr. Ricardo Antara. Just a moment. I will switch off the timer. And then thank you once again for your presentation on crypto contract. So finally, we will listen to the presentation, the last presentation that will be delivered by Dr. Sulaiman Dorloh. So before he starts with his presentation, let me briefly read his CV, his curriculum vitae. So Dr. Dorloh is a lecturer in the Islamic Studies Department, Sultan Idris Education University, Perak, Malaysia. So basically his expertise is in Islamic law, and he has produced some publication about Islamic law. There are women's rights, etc. in Islam. So now it is time for Dr. Dorloh to deliver your presentation. For the host, Pak Fahron, could you please help Dr. Dorloh share his PowerPoint, please?
Yes, wait a minute.
Okay, thank you. Anyway, so Dr. Dorloh, it is now your time. Okay, your presentation now is ready. Okay, so time is yours, please. Thank you. Could you please unmute your mic, Mas Fahron? Tolong di unmute mic Dr. Dorloh. Could you please unmute? Your mic is off. Okay, good. You may start your presentation.
Okay, Assalamualaikum warahmatullahi ta'ala wabarakatuh. And a very good morning. First of all, I would like to express my from Brawijaya University for allowing me to present my presentation, online presentations. I would like to convey my sincere gratitude to Dr. Ibu Afifa for his time, his hospitality, allowing me to do my presentations. The topic of my presentation is stated in my slide point, private personal law in Thailand, with reference to women's rights after divorce in certain border provinces of Thailand, namely Patani, Narathiwat, Yala, and Satun issues and a way forward. Basically, my presentation will be touching on right of Muslim women in those 4 provinces under Muslim family law and law of inheritance code 1965. This is the kingdom of Thailand and Deep South. I'm going to focus on the law, Islamic law, which is applicable in Pattani province, Yala, as well as Satun province, but not other provinces. The content of my discussions, of course, I will briefly begin with the objective of my research, followed by type of dissolution of marriage in southern border provinces under the Code 1941. There are so many types of dissolution of Muslim marriages. I will focus only today, inshallah, on 3 types of dissolution of divorce, namely divorce by conditional agreement. In Arabic, we call ta'liq, talaq with ta'liq. Secondly, divorce by physical defect. In Arabic, we call talaq bil fasqi. And last but not least, dissolution of marriage by way of cruelty of husband. In Arabic, we call it shari. I will end up my discussion with conclusion and recommendations. Next slide, please. The objective of my research, because I'm come to cross that there are some criticism made by non-Muslim writers as well as Muslim writers regarding the right of Muslim women under the Code 1946. That's why I try to highlight some legal provisions on dissolution of marriage under Mafalik 1941 in order to explore and highlight code provisions and to investigate, examine the provision of the code as well as the procedures. And of course, references shall be made to decided cases that have been decided by provincial court and the Muslim Regional Committee Council in those 4 provinces. This is because I firmly believe that the implementation of Islamic law in Thailand, especially in those 4 border provinces of Thailand, could not be ignored. In Thai context, especially when we refer to Thai constitutions, state clearly in section 3, the freedom of religion, the freedom of professing Islamic religion. In relation to marriage, divorce, inheritance, for the Malay Muslim in the Deep South, the study has to be done urgently. And those rights are contained in the Mafalik 1941. And those codes are in accordance with the Islamic law to some extent. Next slide, please. When we talk about the application of Islamic law in southern border provinces of Thailand, as I mentioned earlier, Pattani province, Yala province, Narathiwat province, the court jurisdiction is very important. I would like to briefly mention the type of court. In Thailand, we have 2 types of court. First, we have a provincial court. We may call state court, having jurisdictions over Kingdom of Thailand. And second type of court, we have religious court. We may call native court. When we talk about the court, then of course, the issues of jurisdictions, the issues of mutual trust between two court systems having different jurisdiction and aggrieved party who professing Islamic religion, whether they allow or they are given ample opportunity to bring their case to the provincial court, or they may have an options to bring the case to the religious court. What about the Muslims who are living in our neighboring country, for example, Malaysia, Kelantan, Kedah, northern part of Malaysia, whether they will be given opportunity to file Islamic law case to the religious court or native court in those 4 provinces of Thailand. And of course, I'm going to go briefly with regard to provincial court, or you may call national court. In Thai, we call Saan Changwat, Magistrates Court, presided by Datuk Yuditam. Datuk Yuditam is a Muslim judge, appointed by Thai government, considered as government servant, having legal enforcement, meaning to say that the verdict or decision delivered passed by Datuk Yuditam, having legal enforcement, and of course, the case will be presented by lawyers, irrespective whether they are Muslim or non-Muslim. They may present Islamic law case to the national court, whereas religious court will be presented by Qadi Darul Syar'i. Qadi Darul Syar'i is appointed by Muslim Religious Committee Council. Then is given the title we may call Qadi Syar'i Daruri. And of course, the decision passed by Qadi Darul Syar'i having no legal enforcement, because that only time considered the judgment delivered by Qadi Darul Syar'i is religious, having religious enforcement. But this court having jurisdiction over a Muslim who are staying in northern part of Malaysia, namely Kelantan, Kedah, and Terengganu. So many applicants from those countries come to us and consult with the asking for legal judgment on personal matters. And of course, this court will not be presented by lawyers, but this court, the religious court, opt to apply amicable settlement or sulh, because it is rooted in the Holy Quran. Allah says, subhanahu wa ta'ala, Allah says in the Quran, وَالصُّلْحُ خَيْرٌ. Amicable settlement is among the best tool in order to tackle any problems arising, especially military problems. Next slide, please. Just now I mentioned that the first reason why the government allowed these 4 border provinces to implement Islamic law, the first reason proposed by the government, because for them, they believe that their opinion that the implementation of Islamic law cannot be ignored in Thai context, especially in addition to marriage, divorce, and inheritance only for Muslim in Deep South, because they are living primarily in area near to northern part of Malaysia Peninsula. Moreover, in those 4 provinces in the south, they are not immigrants. They are not considered as immigrant community, but they are considered as indigenous people to those areas. That's why the government categorize them as a Malay Muslim community, being a non-Malay Muslim and Malay professing Islamic religion in the country of Thailand does have law governing, especially to the need of Muslim in those 4 provinces. But my presentation, I will be focusing on the right of Muslim women. The second reason, next slide, please. The study of Islamic law become our belief, part and parcel of our belief. The searching or study of Islamic law is an obligatory. And of course, this is a very important article. The third reason, by virtue of Article 3, the name of the Act is the Act on Application of Islamic Law in Patani, Naratiwa, Yala, and Statute 1941, stated to the fact that the family law is considered as leg loci, it's considered as land of law of the land in the kingdom. In fact, there are several legislation that govern the rights of Muslim women in 4 southern border provinces of Thailand. Those rights include right of married and divorced women. The legislation govern such protection can be referred to Muslim Family Law and Law of Inheritance Code 1941 and Maflalik 1946. For 1941, the special or the obstacle for non-citizen, I'm referring to a Muslim who's staying in northern part of Malaysia, they are not allowed to apply Islamic law in our provinces because the requirement under Article 3, aggrieved party must be a Muslim, reside or stay in those 4 provinces. Meaning to say that a Muslim, whether you stay in Thailand, but they domicile, they used to stay in Bangkok, for example, they will be deprived of their right to apply Islamic law as applicable to the Muslim or staying in the northern part of Malaysia. Next slide, please. I just want to stress the importance of Article 19, Act of 1941. It was stated earlier, as I mentioned earlier, this act is applicable in those 4 southern provinces only, namely Patani, Naratiwa, Muara, Yala, Nipo, Yala, and Satun, just adjacent to Malaysia, northern part of Malaysia. As I mentioned earlier, different laws, different jurisdictions, and different interpretations. In my slides, I just want to compare comparative study between Thai Civil and Commercial Law Code 1934 and Maflalik 1941, applicable in Patani, Yala, Satun, and Naratiwa. The relevant provision, the relevant sections are 1516, 1516, clause 4 and clause 6, whereas Maflalik 1941, I'm going to refer the time given to me, Article 33, Article 92, clause 2, Article 110, and Article 111. Those articles I'm going to discuss in detail. Next slide, please. This is the code of the Thai Commercial Codes. And Article 3 of Thai Constitution allowing Muslim and non-Muslim to practice according to their religions. Basically to say, freedom of religion freedom to practice according to their beliefs is stated clearly under Thai constitutions. Next slide, please. Next slide, please. This is the Maflalik of 1941. Next slide, please. Maflalik 19 กฎหมายอิสลามว่าด้วยครอบครัวและมรดก And this is explanations of the provisions under Maflalik 1941. As I mentioned just now, under the Maflalik 1941, recognize so many types of dissolution of marriage. I will begin my discussion by focusing on sections Article 92, Clause 4, Maflalik 1946. 1946 provide to the effect that I read, besides a husband being able to divorce his wife, a talaq may take effect when he has pitan bun, talaq, which he has been given to him by his wife. For your information, the word pit is Thai language, mean to break, whereas the word tan bun mean a promise not to break, a promise of good behavior. In this context, it is translated an act of breaching a marriage agreement, an act of breaching a talaq agreement. For your information, in other jurisdictions, for example, in Malaysia, a reading of a talaq agreement is a must. It's an obligatory for the party as well as the husband to read in front of registrar, but in Thai context, they have to read talaq agreement in front of imam. The question arises whether the requirement to read a talaq agreement is obligatory or it is an optional. In other jurisdiction, in Malaysian jurisdiction, in Malaysian context, reading of talaq agreement is must. You have to read. If you fail to read, the officer will not allow you to register a marriage. Marriage has been legally solemnized, but registration, the problem of registration, the officer will not produce a marriage certificate. But in Thailand, especially in those four southern border provinces, it was stated, but the imposition of the rule and regulation to force the party to write a talaq agreement is unclear. Usually, a talaq expression contains vows not to break, not to beat, not to break the agreement, vows not to beat the wife. In such a vows are broken, the wife in those four provinces have the right to choose either to apply for dissolution of marriage by the court. If they prefer to bring their case to the state court, the decision we will call and the marriage as stated in the divorce certificate court order, meaning that national court order, Thai court order. Whereas if the decision delivered by Muslim Judicial Council, we may call the authority given by them to break the marriage, the relationship between husband and wife. The procedure is this. A married woman will firstly make a complaint to the imam. This is a procedure, normal procedure. In her respective village, the imam will receive on behalf of the Muslim Judicial Council, and the married woman will have to bring two reliable witnesses to the office of Muslim Judicial Council for further investigations. The committee will make necessary investigations as to why the complaint is made, whether the party have made necessary effort to bring about reconciliations. These procedures is applicable to Muslims who are staying in those 4 provinces, as well as Muslims who are staying in the neighboring countries, namely Kelantan, Terengganu, and Malaysia, Kelantan, and Kedah, and Kedah. The committee will thereupon will ask the married woman to fill a ta'liq complaint. A ta'liq complaint is written in Jawi language. It's not in Malay language. It's considered a religious document issued by Muslim Judicial Council, and of course, if that religious document brings to Malaysian authority, they have go through process of authentication process. The committee will therefore ask the married woman to fill a ta'liq complaint, and witnesses must be complete a witness examination form. The committee will therefore examine the validity of marriage certificates and make several inquiries as to why the complaint is lodged, and whether the party have gone through reconciliation before Imam. As mentioned earlier, in those 4 provinces, the practice of as-sulh was sulhu khair. Allah mentioned in the Quran clearly, was sulhu khair. National court to form a reconciliation committee for the purpose of investigation Islamic cases or Muslim cases, especially a Muslim who are staying in the 4 provinces. But the law governing reconciliation is not law issued by judicial body. That law is issued by administrative body. But as long as the philosophical approach is in order to help to explain, in order to resolve the problem between the parties, we look at the importance of implementation of a sulh rather than to look at where the law coming from. And in most cases, the committee received a complaint from the wife. We need to say that the wife in southern border provinces of Thailand, even though we are living in pandemic, COVID pandemic, and of course, medical problem, especially economic recessions, a quarrel between husband and wife is normal. Lacking of job, for example, income insufficient. So the wife simply may apply for dissolution of marriage by ta'liq. The ta'liq agreements, as it was stated in the landmark case, when we talk about ta'liq agreement, through my research, I found that there are very interesting case. The case decided by a Patani Muslim Council. It was stated in case of Hamak against Fisoh Molo, civil suit 761 1990. The respondent in this case alleged that the husband deserted her and her children for over 1 year. The learned Dato' Itam in this case was an opinion that is entitled to apply for dissolution of marriage. Next slide, please. This is a sample of lafaz ta'liq. I read, bahwa adalah saya, namun suami, dengan ini berta'liq. I solemnly like to express the ta'liq agreement. Manakala saya tinggal kolok pajak. Number 1, referring to this act of desertion, neglect. The classical verb stated in ta'liq certificate is holok pajak. The time period stated in this ta'liq certificate is 4 months atau lebih and over, dengan tiada memberi nafkah yang wajib kepadanya. Failure to provide sufficient necessary, which is obligatory for the husband to confer, to give a maintenance nafkah, but he failed to do so. 2, atau menyakiti. Number 2, referring to act of brutal act of kicking, for example, act of slapping, using abusive words. Is considered as ground for dissolution of marriage by ta'liq. Next slide, please. This slide, just want to share with you kita boleh panggil sebagai surat ta'liq, perjanjian ta'liq. Political acts are considered as a ground for dissolution of marriage by ta'liq. Number 1, physical assault, failure to provide maintenance, desertion. The ground for dissolution of divorce by ta'liq, as stated in Surah An-Nisa, Allah Subhanahu wa Ta'ala says, "Wa'ashiruhunna bil ma'ruf." Translate in Malay language, dan bergaulah dengan mereka cara patut. Treat them with kindness, respective whether you are living in COVID pandemic, we have to take those consideration, and of course, economic recession affected globally, especially in my area. Patani, Natirwat, Satun, and Jala. I think I couldn't be able to finish my presentation. However, I have already submitted my presentation. You may refer to my slide presentations. If you have any queries, you may ask me through my WhatsApp or my email. And of course, I would like to conclude my conclusions, my presentations. That Maflalik 1946 and 41 clearly protect the right of Muslim women according to Islamic law, though the code does not brought to the parliament for approval, and by virtue of this act, application of Islamic law and law of inheritance is applicable in those 4 provinces and other court jurisdictions in Malaysia, in the neighboring country, namely Kelantan, Terengganu, and Kedah State. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Thank you for your attention.
All right, thank you, Dr. Dorlo, for your presentation on women's rights after divorce. So let us all give applause or thumb up on your Zoom screens for all the speakers. Show our appreciation. All right. Thank you very much. Okay, so after this, we are entering question and answer session. But before we enter the question and answer session, I would like to ask all participants to fill in the attendance form. The attendance form has been sent by the committee to your email. So kindly please check your emails, including your spam and folders, perhaps. Who knows, accidentally enter the spam and folder. Okay, so now we enter question and answer session. There are several questions for the speakers that have been written by the participants. I will read some of them first. So perhaps to give time, and we are not in stress, something like that. For the first round, I will read. So some questions are coming anyway. I will read for the first round 3 written questions, and after that, I will open another round until all the questions hopefully will be answered by the speakers. So the first one, the first questions is given by Ms. Nanda Saraswati to Professor Anselmo Reyes. Let me read that. So good morning, Indonesian time. So Nanda from Brawijaya University would like to ask Professor Anselmo Reyes. First, to compare with Indonesia, what is or what are the legal reasons for Laos and Myanmar, and perhaps also for other countries who or that are showing slow response towards the ratification or accession of Apostille Convention? So basically, what are the legal reasons, or perhaps also other reasons? And then second question from Ms. Nanda is, although Indonesia have not accessed Apostille Conventions, but she thinks that the process is already started, some discussion, something like that. So currently, notaries, according to her, have no role in process of legalizing foreign documents, notaries in Indonesia. So her question is, when Indonesia finally ratified or accede to Apostille Convention, what will be the role of the notary, if any, in the process of simplifying or legalizing foreign documents? Thank you. And then the second questions, and also the third question, in fact, are directed to Dr. Dewantara. So first from Ms. Natali from Universitas Indonesia. Her question is, since smart contract is irrevocable, what can the parties do if they want to terminate the contract because of misrepresentation, mistake, or duress? Second question to the same Dr. Dewantara from Ms. Farah, Universitas Gadjah Mada. Is there any rule about jurisdiction or competence when there is a dispute or where there is the crypto contract will be implementing? So she is asking basically how to determine the jurisdiction in the case the crypto contract will be implemented. And then her second question from Ms. Farah is that if the parties do not choose or do not make a choice of law, and there is dispute raised from the crypto contract, what the principles of private international law that most commonly used to settle the dispute? So I think the first opportunity will be given to Professor Anselmo Reyes to answer Ms. Nanda's question. Time is yours. Thank you. Mas Fahron, could you please unmute Professor Reyes?
Thank you very much. I thank Nanda for her questions. The first question relating to Laos and Myanmar, I'm not sure what the reasons are at the moment in relation to Laos and Myanmar for not considering accession to or signing the Apostille Convention. Let me generalize, however, from my experience when I was representative of the Hague Conference's regional office, Asia Pacific, in Hong Kong. For many countries, including Indonesia, one obstacle that has made countries' governments hesitant to join the Apostille Convention is this. The Apostille Convention radically reduces the number of authentications needed for a document. Consider the most common form of document, the most usual document for which authentication is needed. That is usually the school certificate. So you graduate from some secondary school or from some university. The document, your certificate, is recorded in some government database, some repository. Usually, every time that someone needs to have a document authenticated, you go to one particular government office, and then you may have to go to another government office to authenticate that that was the correct authentication by the previous government office. You may have to go to a consulate to authenticate that that was the correct ministry that authenticated the document. You may have to go to another place to have the authentication of the consulate authenticated in another country, and then another ministry authenticates. You can have a whole series of authentications. What this means, therefore, is that a number of institutions, organizations, will have a source of income because authentications are not for free. you have to pay for the authentication. If you radically reduce the number of institutions that you need to go to for authentication, that inevitably means that some institutions will no longer have their usual source of income. Those institutions that that authenticate authentications of others will drop by the wayside. They will have to look for other sources of income. So within a government, various government institutions may be worried that if the country accedes to the Apostille Convention, they will lose out on a source of income and they will have to find another source of income. That has been the typical stumbling block for accession or joining the Apostille Convention. It's the fear within a government that some institutions within that government will lose a source of income and will lose a vital source of income. If you think of the number, for instance, of school certificates that are authenticated in any given country in any given year, Indonesia is no example because in order to work abroad, a lot of Indonesian domestic workers will have to have their school certificates authenticated. That could be a considerable amount of money. If an institution will lose out because it will no longer be able to authenticate, you only need to go to one place for an authentication, that may be a matter of concern to the institution. That's really, I think, the major concern with acceding to the Apostille Convention. Otherwise, acceding to the Apostille Convention might be regarded as a no-brainer. You should really do it because the citizens of your country will benefit from having just to go to one place for authentication, and then their document can be used in all the other over 100 contracting states of the Apostille Convention. The second question is, what is the role of the notary if a country accedes to the Apostille Convention? And here, the role of the notary becomes very important. I suggested earlier on that the Apostille Convention deals with public documents, the authentication of public documents. The Hague Apostille Convention does not actually define what a public document is. It is left to each country, each contracting state, to define in its law what it understands to be a public document. There is, however, one exception. All countries that accede to the Apostille Convention are entitled to have a notarial certificate treated as a public document. So all countries must treat a notarial certificate as a public document. So what happens? What you can do then is, I need to sign an agreement. I talked about my own circumstance. I go before a notary here in Japan or some other contracting state of the Apostille Convention. I sign the document in front of the notary, and the notary prepares a notarial certificate attesting to the fact that I identified, he looked at my identification, I signed the document, the agreement, let us say, before the notary. So the notary looks at my document, sees me sign the document, and then does a notarial certificate attesting to that effect. That, under the Apostille Convention, is a public document. So that can be subject to an apostille. You can then go to any country and present that notarial certificate, notifying, authenticating that you signed the document before the particular notary. So it doesn't say anything about the truth or falsehood of the contents, but it validates, authenticates the notarial certificate. So under this, you can effectively produce authentic acts using a minimal amount of procedure, using just one apostille. You can produce these for use in other countries. So it's very, very convenient. And that means that the role of the notary becomes very important, very crucial in if a country exceeds the Apostille Convention. Now, it seems to me that that would be very advantageous to Indonesia, because all over Indonesia, in keeping with the civil law process, wherever you go in the Indonesian archipelago, my experience is there is a notary, there is a community notary. So you just go down a few steps to your community notary, have your act deed notarized, and then you can produce it in other contracting states of the Apostille Convention with the notarial certificate, which is duly authenticated by an apostille, or hopefully ASEAN can develop these things so that everything can be done remotely. You go to the notary using remote technology, the notary sees you, the notary sees you. I think we can develop a system of remote technology to take full advantage of the Apostille Convention. If necessary, if Indonesia would like, it can join the Hague Conference and then use the Hague Conference's technical assistance to develop a system for itself. Thank you.
Okay, just a moment. Dr. Dewantara, are you ready to respond the questions? Thank you. Thank you, Prof. Anselmo. I'm sorry to say before. Thank you very much for your response to Nanda's question. Yes, please, Dr. Dewantara.
Okay, thank you, Ms. Natalie, for the question that since smart contract is irrevocable, what can the parties do to terminate the contract because of the misinterpretation? So I have been saying that in the smart contract or the crypto contract, there was a 3 mutual assents, so we call it the consensus. So the parties on the crypto contract must have 2 permissions. For the first, we can say that the permissions for the blockchains. If the blockchain is a permission, it's when the parties or the participants are pre-selected or the subject have or get the gated entry based on the satisfaction of the certain requirements that have been approved by the administrator. So the permission blockchain, it can use as the consensus protocol for determining. And then the second one, or the second step, is the permissionless from the blockchains. Is if we are to submit a message for the processing, or it can be involved in the process of reaching consensus. Maybe we can say that if the parties or one of the parties is say that I think the clause from in the smart contract is a misrepresentation, or I cannot accept this clause. So this clause or this smart contract will off or will undetermined by the blockchain. Or the consensus of the protocol, we got another one permission is from the computer protocol. This is the form of an algorithm constituting that have been set of a rules. I think each participant, each have the blockchain for process the message. Maybe we can say, okay, the transaction is accepted. So it will be translated with the cryptography. Or sometimes we can say that the participants all should accept it. Not only one, but all of the participants should accept the processing that done by another participants. So the purpose of the consensus protocol is to achieve the consensus between the participant as to what the blockchains or the ledger should contain at a given time. So the term, I think it can use 2 words. It can say that the proof of work or the proof of the stake. So if the proof of work or the proof of the stake can be undone by one of the participants, so the smart contract or the crypto contracts will not be due for the next step. So we can say that it can be the breach of the contract if the one participants doesn't get the proof of work or the proof of the stake. And then the second question, this is from Ms. Farah. Thank you, Ms. Farah, for the question. The one is there any rules about the jurisdiction? I have been saying that About the jurisdictional questions with respect to smart contract, it can say that it operates with the connection with a distributed ledger. We call it a blockchains. So where is the distributed ledger is located if this dispute arises. So I think if we use the jurisdiction or we use the international private law principle, what is the international private law principle that we can use? So we can use lex loci contractus. We have to know that lex loci contractus is the applicable law that law is in place at the agreement or the contract made. So where is the contract made? So we can have to know that the contract made is made by the where the distribute ledger is take place. Or we can say that we can interpret that we can use the lex loci solutionis is the laws that apply to a contract is the place where the contract is implemented. So if the seller and the buyer, the seller is from Sweden and the buyer is from Indonesia, so and then the dispute is happened in Indonesia, so the lex loci solutionis it can be the answer where is the contract is implemented. But some scholars say that there was two theory that we can use if there are any misrepresentation for the where is the jurisdiction that we can use. The first one, we can say that we can use the theory of the proper law theory. The proper law theory is the contract is the most legal system that's close and real that the transaction is occurs. Or we can use the most characteristic theory connection. I think this is the most characteristic is where is the repulsion measures that the legal determination is to be regulated for the agreement. So I think we can use that the principle of private international law if there was the parties is to not make the choice of law or to not make the choice of forum. Thank you. Mungkin, okay, thank you for the attention.
Thank you very much, Dr. Reka, for your clear answer. So now there will be the second round, and I would like also to express my thanks to the participants who raised this question. So means that you are following this seminar. So the second round, there are also 3 questions given by the participant. Let me read first. So the first one from Mr. Hamri from Universitas Makassar. This question is directed to Dr. Dorlo. So basically, his question is, how or what the rules for the distribution of maintenance obligation and child custody between husband and wife who have different nationalities and they are divorced. Okay, I hope that you are following me. So this is the first question to Dr. Dorlo. And then the second question, basically, he started by writing like this. These 2 questions is directed to any speaker who capable to give me advice. So to any of you who could help him. So this question is written by Mr. Eric Rizky from Pajajaran University, Bandung. First question is, could you please give me an opinion, your opinion, about global sport organizations such as FIFA, the one in the football, I guess, in developing international law? Because according to Mr. Eric, the global sport organization such as FIFA, as a non-state actor, has done global governance like a public organization. So what is your opinion about this global organization like FIFA in developing international law? So it could be Professor Reyes, it could be Dr. Sanchez, if you would like to give your opinion. What is this role of global organization in developing international law? And then the third question is written by Ms. Anissa. I do not know her university. I think from Universitas Veteran in Jakarta. Directed to Dr. Dewantara regarding smart contract. First is privacy policy from certain e-commerce app, in your opinion, a type of smart contract? And then her second question from Ms. Anissa, what about the consensual term in the contract if the contract has been made exclusively by the app maker without consumer involvement, while the consumer just tick the agreement box without understanding clearly the content of the contract? In your opinion, is it called a standard clause? And what is the effect of this? So I think this is the very interesting. So the second round of the question and answer session. So I let first Dr. Dorloh to answer, then either Professor Reyes or Dr. Sanchez, and then finally Dr. Reka. Thank you.
All right. Is it okay?
Yes, please, go ahead.
Okay. Thank you for your questions. I think is Brother Hamri? Brother Hamri asking me about involving international laws. I think first of all, I would like to say something about the law, the application of law in southern border province of Thailand. According to the Thai government, they call a special law, special concessions law, special concession given to the Muslims to apply Islamic law. This special concession to apply Islamic law is also applicable to the neighboring states. The state of Malaysia, for example, Kelantan, Terengganu, and Kedah. The term of application is persuasive applications, having no clear cut on the issue of distribution of prices as well as custody of a child. Is still debating in the provincial level. And inshallah, we try our effort to upgrade the status of the special law to the level that recognized by international community. Thank you very much.
Okay, so that's all. All right.
That's all from me.
Okay, so thank you very much, Dr. Dorlo. So for the next question, who is willing to answer? But basically, Mr. Eric, add some more explanation about his, what is the name? Oh my God. Oh God, where is that before? Basically, he considered like this organization as a private, but quote and behave like a public organization. If they are non-state actors because they are private organization, but they are doing global governance. So this is Mr. Eric's question actually. Mas Fahron, tolong unmute Prof. Anselmo ya. Halo. Tolong biar Pak Prof. Anselmo sendiri yang mute and unmute, okay?
Unmuted now. May I suggest that for the purposes of this discussion, that the participants be left unmuted so they can intervene in each other's comments and add to each other's comments. In answer to the question about sports, I cannot speak for FIFA, FIFA, but perhaps I can say something about sports arbitration and the development of sports arbitration law. This year was supposed to have been an Olympic year in Japan and for the rest of the world, but because of COVID-19, it has been postponed to 2021. Now that gives some time for Japan to develop expertise in sports arbitration. In the course of any given international competition, even competition within, say, ASEAN countries, there will inevitably be questions about doping, whether a candidate should or should not be allowed to participate the next day. There will be questions about whether a disqualification should be or should not be permanent. These questions will arise in the course of any international competition. Perhaps a lot of questions will arise as to the validity of certain test results, will arise on a day-to-day basis and will need to be resolved quickly. So that every country, Indonesia included, because Indonesia often hosts international games and will be doing so, I believe, even after COVID-19. Every country that hosts or wants to host international games will have these problems, and it would be a good idea to have capacity building, a local number of experts in sports arbitration or sports law who will be able to give quick decisions on matters on urgent basis. And so the question is, what is the role of sports organizations in the promotion of international law? Well, one role, it seems to me, is to help develop capacity within countries, including ASEAN countries, including ASEAN, including Indonesia, to develop capacity in dealing with sports arbitration, in dealing with the questions that arise in international, regional, quasi-regional competitions. These are very much a reality of our time, and it seems to me that it would be good for all countries to have a capacity to do so. And that, I think, is an important role that sports organizations can play.
Okay, so that's all. Oh God, I already thought. Okay, I'm sorry about that. I already told Fahron. Perhaps he does not read my message. I'm sorry about that. Okay. Yes, please, Dr. Reka. So thank you, Prof. Anselmo, for your answer. Now, next, Dr. Reka, perhaps could give your answer to the question.
Okay, thank you, Dr. Afifa. But maybe Mr. Eliezer, Dr. Eliezer is want to answer first before I answer the third one. It's okay.
Yes, please. If Dr. Sanchez want to respond about the question about the consensual term in the contract, the one that I mentioned earlier, you are welcome. You're welcome. You cannot unmute it.
Okay. I missed that question, but
Okay.
I managed to read a question about foreign direct investment. And to the best of my knowledge, usually these are regulated under bilateral agreements. And usually parties will have a clause of arbitration. And the assumption is that the applicable law will be the Lux 40, which is the law of the country of the arbitration body that has been chosen by parties. Perhaps there will be a express choice of law. They want to regulate, to govern the contract for this foreign direct investment. But we need to bear in mind as well that there is most countries in the world, they have statutes, they have legislation regulating how foreign direct investment happens, and there might be in every jurisdiction provision attracting the case, and this goes in line as well with the question of smart contracts, because in my paper there is a mention to a recent case in Australia, the ACCC, the Australian Consumer Competition and Consumer Commission, and Valve is a case where, well, it's not smart contracts properly, but it's the case of a video game. It was a platform for video games that were based in the United States, but it was accessed by game players here in Australia and New Zealand. And what happens is that the choice of law that was in that contract, that was notable for all the users, is just overridden by consumer law. And I just wanted to put this before Professor Rica the Antara answers the question, because usually the choice of law and freedom of contract is always limited when contracts are deemed to be consumer contracts. Well, thank you so much for the question.
Okay, so that's all. Thank you, Dr. Sanchez. Dr. Reka, please.
Okay, thank you. I will answer, but from Anissa, that's the question is privacy policy from certain e-commerce is a type of smart contract? I have been give some explanation about what is the smart contract. The smart contracts is sometimes meet a number of conditions that imposed by law, and then the capacity of the parties is still needs the mutual assent and the consideration. But and then sometimes the contract in traditionally it's maybe sometimes it can be oral, and then certain contracts must be in tangible form. But in the privacy policy, we have to know that the privacy policy is just like the browse wrap categories contract. Why? Because the parties in the browse wrap categories, they can make some the inquiry notice that the terms must write in the contract in the contractual terms. So if the privacy policy is a smart contract or not, my answer is not. Why? Because the privacy policy is just the clause or it's just a part of the contract, but it's not the contracts for but it's not a contract because not a smart contract because it can execute by itself. So the privacy policy is the part of the contract, but it wasn't the smart contract because it cannot executable by itself. And then the second question is how about we can say that the smart contract is a standard contract or not? I can say that this is the standard contract. But I have been saying that if this is the standard contract, why this is the standard contract? Because the party that made the contract is the distribute ledger or the person that made the blockchains. So if the parties doesn't want to use or doesn't require didn't have any requirement to click the wrap of the categories from the smart contract, so this smart contract can do itself executable. So if you ask that this is the standard contract or not, I say this is the standard contract. Why? Because this is made by the ledger or the system by the blockchains. Okay, thank you.
Okay, so thank you so much for your answer, Dr. Reka. I think I will open the last round for this question and answer session. But there is
Sorry, Dr.
question.
I wonder if I might ask a question of Dr. Sanchez Lazabalet.
Oh, sure. Just go ahead. Yeah.
I'd like to thank Dr. Sanchez for a most interesting paper. My court, the SICC, is both a common law and a civil law court, and we can accept submissions directly on matters of foreign law from foreign lawyers, although we accept it in English. So, in fact, in one of our cases, we had submissions directly from Indonesian lawyers, from an Indonesian professor of law, on a matter of Indonesian law. Now, my question to Dr. Sanchez is this. To what extent would it be possible, you think, in practical terms, for common law courts to switch from treating questions of foreign law as matters of fact to matters of law, which seems to be more logical? Secondly, if you don't think it is practical, if you don't believe that common law jurisdictions can do so easily, do you believe that there is a danger? You referred to manipulation of foreign law by parties. You think that there is a danger if I believe that foreign law may be unfavorable to me, for instance, if I'm a party, I don't plead foreign law. I prefer to have the court apply the lex fori in some matters. Other matters where foreign law is favorable to me, I plead it. And so what we end up having in a case, because a case may have a number of incidental questions, you may have depassage, where different parts are treated in different ways. You may have a whole amalgam that is neither consistent with the lex fori, nor consistent with the foreign law. You have something strange, manipulated by a particular party. Is there not a danger of this if common law courts do not change their rule?
Okay, could you please unmute?
For
Could you
that
please?
question, that observation, yes, I think in common law jurisdictions, there has been paying some attention to states in the United States that will have a much more civil law leaning. And instead of thinking of foreign law as a matter of fact, they may have foreign law treated as a question of law. And I think it's not difficult because in that case I mentioned Damberg and Damberg by Justice Haddon, you could see him acting as a civil law judge, conducting his own investigation. In that decision, you can read he looks for the provenance, the pedigree of this idea, and I think times are changing. This morning, I just saw that Barbados is departing from the Commonwealth and becoming an independent republic. And I think in that sense, that was a rule, considering foreign law as a question of fact, that was very convenient when we had England as an empire in colonial times. And I think what we see in Australia since perhaps the last 30 years is a need for getting closer to other trade partners, and also upholding the idea of freedom of contract. So I don't see this very difficult, but there are still things that need to be changed in terms of how common law jurisdictions perceive themselves as adversarial, as opposed to civil law jurisdictions that they tend to think that civil law jurisdictions are inquisitorial. So perhaps this is the reason why the judge tries not to get involved in conducting his own investigation in regard to the foreign law. But from that precedent in Damberg and Damberg, it was very clear that for them that tax law was not embedded, was not part of big legal principles existing in German law. So for this reason, they couldn't extrapolate what they saw in German tax law into Australian tax law. And then the case was decided on other grounds. But I don't see this as difficult. It's just a question of modifying perhaps evidence law in order to think, well, still, if you argue having a claim or a defense on foreign law, you need to prove it.
Okay.
I hope I have dealt with the whole observation. Thank you, Professor Anselmo Reyes.
Thank you.
Okay, I think there is a question, sorry about that, a question from the student. His name is Nico. I already wrote to your private chat, Dr. Dr. Sanchez. Could you read that?
No.
Okay, I will read for you in the chat box of Zoom, but I will read for you. So Nico, give question. Dr. Eliezer, according to your presentation and in your opinion, may I ask you how to regulate foreign direct investment in every nation based on the standard and or the usual, but it is a foreign direct investment. Yes. I think it is, okay, it could be answered either by you or by Professor Reyes.
Yes, I think I mentioned foreign direct investment in my
as well.
Answer.
Okay.
And to my mind at the moment, to the best of my knowledge, is that usually they are regulated under bilateral agreements, and usually parties will put a clause of arbitration, and usually what is going to happen is that there is this presumption that the applicable law will be that of the forum, that of the country, of the arbitration body that's been chosen by parties. So this is how I can deal with this question. Other than that, we need to look into foreign direct investment legislation in every country to see if there is a provision whereby the country will try to attract litigation to the courts because perhaps on more protective stances, some countries will try to attract litigation in their courts in order to protect the local industry.
Okay, so thank you for your answer to Nico's question. And then Nico also raises a question to Dr. Dewantara, once again about crypto. And I send it to the chat box in your private chat box, but if you cannot read it, I will read for you. Is it relevant if the regulation of crypto contract is only regulated by technical law? As we know in financial service regulation. Is there no any higher regulation or statute that clearly regulate crypto contract in Indonesia? So basically he asked whether it is treated as a technical regulation. There is no higher regulation or statute related to this. Do you think that in Indonesia we need to codify or make a code that govern the substance of crypto contract? So this is basically his question. Thank you. Could you please unmute? Okay.
Okay, thank you, Dr. Afifa. Okay, maybe it's not only the question, but it also will be the thesis for his subject, maybe. Okay, for the first question is, according to your presentation, is it relevant if the regulation of the crypto contract is only regulated by the technical law, as we only know is only in POJK? Okay, I will answer that the legality, we have been know that the legality of the contract that has the mutual assent from the party has same legality as the act. So, but I have been made some for the reformulation or the reconstruction. If we will make or meet the regulation, how is the regulation? We have been know that crypto contracts is preserve the best features of the traditional contracts. So if we didn't have any rules or we didn't have any regulation about the crypto contract or the smart contract, I think we will make the including of the clause is the ability to be renegotiated in the future if this is necessary. And then the contract must be needed to validate. So the person or the party, the seller or the buyer or the insurer or the another parties, they must be validate the smart contract in any litigation or any clause. It also including the verifying that the security protocols, because it's the sufficient to maintain the code that must be agreed by the parties. And then if we want to make some code, or we will make some the convergence or the transplantation of the rules or the regulation, I think the reformulation of the rules or the regulation not only in government regulation, or not only in financial supervision authority regulation, but it also we will make some act that convergence about the information technology and the financial. What will, maybe if you want to know about the structure of the rules, maybe we can say that first, it might be rules about the mechanics of contract formation. The second one is rules about the enforceability. The third one is rules about the jurisdictional issues. And the fourth one, it will rules about the legal ethics that related to crypto contract or smart contract. Maybe it will make you have some idea to make the subject of the thesis. Thank you, Dr. Afifa.
Okay, thank you so much for Dr. Reka. Actually, there is also a Brawijaya alumni, or is he still a student? Anyway, contacted us, wants to raise question but orally, not written. So I allow her to do so. I think it is the last one if there is no other further question. Okay, Merari, you may start. Please unmute your mic. Mention to whom your question is.
Okay, hello, am I audible? Okay,
Yes.
Thank you for the speaker's remarkable presentations. My name is Merari Zahra. I'm an alumna from International Law Department, Brawijaya University. And I would also like to send my warmest greetings to the lecturers and the committee in Brawijaya University. I have a question specifically for Mr. Sulaiman. So I am particularly very interested in international law regarding women's rights. It was in fact something I focused on during my thesis not long ago. And it was very interesting to see you brought up women's rights in this private international seminar. So I'm just curious, Mr. Sulaiman, about your view on the importance or the role of women's rights studies for the development of private international law. For it is something very rarely discussed within private international law during this pandemic or even just in general. So that's my question. And I would also be very happy if the other speakers would want to share their opinion on this. Thank you very much.
All right, so thank you, Merari, for your question. And then, yes, please, Dr. Dorlo, if you want to respond. And also for others, perhaps. I'm not sure if there is a conventions international, but perhaps there is, I'm not sure. Anyway, Professor Reyes could also respond about Merari's curiosity about the women's right, perhaps in the Convention of Private International Law. Is there any that protect women's rights in the convention related to private international law? Anyway, so Dr. Dorlo perhaps ready to answer your question, Merari's question. Could you please unmute? Thank you.
Okay, thank you for your response. I would like to respond on the human rights in private international law. I would certainly say that the rights of Muslim women in southern border provinces of Thailand has been protected by national law as well as Mafia League 1946 or 1941. Even though we consider it as a special law, but women rights still being recognized, protected by this law. They matters bring to international intention because of lacking of data and research done by Muslim scholars, as well as because some issues perhaps bring about by the Muslim scholars, rather to speak in Malay rather not to speak in English, but try to bring this case into international level, inshallah. But for sure, I would like to stress again that Muslim rights, especially Muslim women in southern border provinces of Thailand, has been protected by special law, especially as well as a national law. Thank you very much.
Okay. Any other response, perhaps, about Merari's questions from the speakers? Okay. So thank you, Dr. Dorloff, for your response, and then also thanks for Merari. Okay, so since we have reached the end of question and answer session, I shall close this session and return the program back to the Master of Ceremony. But before that, I invite all participants to give applause or thumbs up on your screen for all invited speakers. Okay. So thank you so much, our distinguished speakers. And then, but before returning the program to Master Ceremony, I'm reminding again the participant to fill in your attendance form before the end of this seminar. So, Ms. Cindy, now time is yours. Thank you, and I apologize if it is I'm not smooth or make mistakes, something like that. Okay, Ms. Cindy, now time is yours. Thank you.
Okay, thank you, Dr. Kusumadara. And distinguished speakers and participants, ladies and gentlemen, next we will have a photo session. We kindly ask all distinguished speakers and of course all participants to turn on your video so that the organizer can take some photo shots of all of us. Okay, to the committee, please on my cue. Okay, 1, 2, 3. And maybe we'll take another one. Please on my cue. 1, 2, 3. Okay, thank you. And also, I would like to remind to all of the participants, the air certificate and seminar materials will be sent to your email address by tomorrow afternoon, September 18, 2020. And please do check your email, including the spam or trash folder regularly. And now our event has come to an end. We would like to express our appreciation to all distinguished speakers and participants for your presence at this international seminar, Private International Law in Asia Pacific, hosted by Faculty of Law, Brawijaya University. I hope that all of us could gain useful knowledge from the seminar. Thank you very much and see you in our next events. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you. Thank you, Prof. Reyes. Bye-bye. Bye-bye all. Thank you.